Are there any other votes? Announce the results.
Ayes 105, noes 0.
The bill is passed.
Assembly 6644D, Calendar 252. Mr. Engelbright, an act to amend the Retirement and Social Security Law.
Read the last section.
This act shall take effect immediately.
Clerk will record the vote. Are there any other votes? Announce the results.
Ayes 103, noes 3.
The bill is passed.
Assembly 8214B, Calendar 513. Mr. Weprin, an act to amend the penal law.
On a motion by Mr. Weprin, the Senate bill is before the House. The Senate bill is advanced. Read the last section.
This act shall take effect immediately.
Clerk will record the vote. Are there any other votes? Announce the results.
Ayes 92, noes 14.
The bill is passed.
Assembly 446, calendar number 35, Mr. Gottfried, an act to amend the public health law.
An explanation is requested, Mr. Gottfried.
Yes, Mr. Speaker, this bill would say that midwifery-led birth centers, which exist in New York and are perfectly legal, could be, first of all, organized as an Article 28 facility rather than simply a group practice by midwives. And just as a dental clinic under Article 28 can have a...
1 minute, Mr. Godfrey. We have lots of people standing around having conversations, and I don't see a reason for it. They can go outside the chamber. Please proceed, sir.
And just as a dental clinic under Article 28 can have a dentist as its medical director, a midwifery birth center would be able to have a midwife as its medical director. All of the laws relating to how midwives practice, their requirement for a backup relationship, etc., would all remain in place.
Ms. Corwin.
Thank you, Mr. Speaker. Would the sponsor yield?
Certainly.
The sponsor yields.
Thank you, Dick. Yes, we had a discussion about this bill last year, and I'm wondering, have there been any modifications or changes since last year?
No.
Okay. The two bones of contention that have been raised with myself and others has been two things. Number one, the doctor's oversight regarding the midwife and who would be supervising or running the center. As you said, current law says that a midwife has to operate under an agreement with a physician, and you say that would still exist with the midwife who would be running a midwifery center?
Well, I would say two things. The law requires a collaborative relationship either with a physician or with a hospital that provides obstetric services delivered by a physician. But yes, all of that would remain 100% in place, just as if midwives are practicing in a midwifery birthing center run outside of Article 28. They are subject to those rules. If they organize as an Article 28, they would still be subject to all those rules, but significantly they would also be subject to all of the to the host of regulations under Article 28, which a private practice, whether it's physicians or midwives, are exempt from.
Just quickly, what is the purpose of creating birth centers as a form of a hospital? What are the advantages to doing that?
Well, the advantages for the public is that the facility would be subject to periodic inspection by the health department, which is not true of a doctor's office or a midwife's office. It would be subject to a long list of regulations under Article 28, which again do not apply to a physician group practice or a midwife group practice. For the midwives themselves, it presumably has advantages in terms of being more able to get financing for the facility and things of that sort. It might also be of use to them in terms of giving the general public more confidence in the establishment because it is regulated under Article 28.
Sure, I understand, but the legislation doesn't do anything as far as requiring the creation of the facilities to be accredited by any national accreditation agencies. Wouldn't that be a way of regulating or exercising some quality control?
You know, a physician who does births in his or her office or who does home births doesn't need to be accredited by anybody. A midwife today who practices in a midwifery birthing center, that center doesn't have to be accredited by anybody. If a group of physicians organize an obstetric birth center, once they have their license from the health department, they don't have to be accredited by anybody. You know, hospitals that do brain surgery are licensed by the health department. Whether they get accredited by some other private organization is up to them. As it happens, I believe virtually every midwifery birth center does get accredited by a national body that accredits birth centers. That's their choice. I would imagine that it would certainly make sense that they would do the same. If we want to start requiring physician offices to have some sort of national accreditation, somebody other than me can introduce that bill and take all the slings and arrows that will descend upon them. But I don't think there is any reason why that should be a new requirement for midwifery birth centers when they don't have that requirement now.
Okay, thank you. Another issue that's been raised is regarding the impact these freestanding birth centers would have in terms of federal and private national payment models. Are you aware of anything that having these centers open would impact in terms of the payments from insurance, and if that would change at all with these centers?
I'm not sure what you're referring to. There may be reimbursement advantages to being organized under Article 28, in which case that would be terrific. There might be good logic to having a higher reimbursement rate for an entity that is organized under Article 28 and subject to Article 28 regulations. That would, you know, that if that is part of, if that's going on today, that would be a good thing.
Okay. And also, if these midwifery centers were to be classified as a form of hospital, would they be required to undergo the certificate of need process the way hospitals do?
Yes. Obviously, the certificate of need process is tailored to the nature of the services that a particular entity is offering. If you're trying to build a 500-bed general hospital, you're going to be looked at differently than if you're trying to open, you know, a neighborhood health center. Likewise, if you're trying to open a birthing center. But all of those provisions of Article 28 would apply. As with other Article 28s, the health department would have authority to make specific regulations tailored to midwifery birth centers.
Okay, great. Thank you, Dick. I appreciate that. On the bill, Mr. Speaker.
On the bill, Mr. Corwin.
Last year we talked about this bill, and there were a lot of concerns that were raised. I've had a chance to take a closer look at it, and some areas I think maybe aren't as much of a concern. For example, having the doctor's relationship with the midwife in terms of the creation of the center and supervision of the center. Clearly, we have situations now where midwives are operating or conducting their services without the doctor actually physically present, and that may be okay. But there are other concerns that I still have regarding the bill. For example, the language of the bill does not give a lot of specificity as to the creation of these centers. Certainly, I'm aware of other institutions, educational institutions, and so on, when they are being created or in the process of being developed, oftentimes will rely on these accreditation firms because it helps to give them best practices information so that when they open a center, they're doing it in the most effective and most cost-effective and service-effective way. Clearly, this bill does not accommodate that. The other issue I would suggest, too, is that not all facilities that provide health services are regulated or appear the same in law. Hospice, for example, is done differently as are assisted living centers because their payment processes, their way of operating do not fit into that hospital model. And I would make the point that midwife centers could very much be classified the same way. In terms of suggestions for the bill, certainly we need more midwife centers or facilities for women. Those services are desperately needed, especially in certain areas of the state. But I would recommend modifying the bill to require some sort of an accreditation process to make sure that when these facilities are created, that they are created in the most effective way and so that we can provide quality services to these women, not just having quantity. Thank you, Mr. Speaker.
Thank you, Ms. Corwin. Mr. Cahill,
Thank you, Mr. Speaker. Will the sponsor yield?
will you yield, Mr. Godfrey?
Certainly.
Sponsor yields.
Thank you, Mr. Speaker. Thank you, Dick. A couple of quick questions about the reason for the need for this bill. Why can't doctors do it now? Why do we need to set up a situation where midwives would be in charge instead of doctors would be in charge? Why can't we do it the way the law says right now? What ill are you trying to fix?
Well, first of all, today midwives are perfectly legally allowed to set up a midwifery birthing center without asking anybody's permission, as long as they do it as a professional corporation. And there are some who have done that. If they want to subject themselves to the additional regulation of Article 28, they can do that, but it requires that that a physician be the medical director. And that really is irrational because just like a physician is not the medical director of a dental clinic under Article 28, there's no logic to requiring a physician to be the medical director of midwifery services when we don't require that in the utterly unregulated context of midwives operating a midwifery center today outside of Article 28. The law does provide for backup relationships with either a physician or a hospital with obstetric services being offered by physicians. That's what's called for. There's no reason why the rules should be any different just because the midwives are choosing to be subject to the additional scrutiny and regulation of the health department.
So if you will, Mr. Gottfried, a couple of further points on that. If a complication arises during a midwife delivery or in the care that's provided at a midwife center, is there any difference between that and if that midwife was at home, at the home of the expectant mother, and a complication arose and then there would be a need for medical intervention? Is there any difference whatsoever?
Well, first of all, the facilities that are available at a midwifery birthing center, whether organized as a group practice or organized as an Article 28, are dramatically different from the case of a home birth. People often associate the word midwife with home birth. The truth is there are very few home births in this state being performed by anyone. And actually, the last time I saw statistics, there were more home births in New York being performed by physicians than by midwives. So the real question would be to compare midwives practicing in a midwifery birthing center outside of Article 28 versus inside Article 28. And if they operate inside Article 28, there would be dramatically more standards and regulations that they would have to comply with. The rules requiring a backup relationship with a physician or a hospital would be exactly the same.
Dick, is it your information or experience that there is a hesitancy on the part of OBGYNs or other doctors to become the sponsoring doctor for a facility, and therefore there's a limitation on the proliferation of these facilities where there might otherwise be a demand?
Well, so few midwives have sought to organize under Article 28 because of the current law that I'm not sure you could document that hesitancy, but certainly there have been many cases in which midwives back in the days 6 years ago when they were required to have a formal collaborative agreement, there were many cases in which midwives' practices were shut down because the doctor in town who was willing to sign a collaborative agreement, had retired or moved somewhere else. So that's why we changed that law 6 years ago. So I would think you could expect that it would be difficult for midwives to find a physician who was willing to have that degree of a formal relationship. And if that formal relationship were justified, then you could say, well, too bad, you have to have the doctor, head of the clinic. But there really is no reason for that. And if the midwives choose to practice as a group practice, they don't have to have any medical director, physician, or otherwise.
Thank you, Dick. Mr. Speaker, on the bill.
On the bill, sir.
The creation and the authorization of midwife centers across the state of New York is something that would be a terrific advancement in health care. Placing them under the regulatory scheme of Article 28 would also provide an additional level of checks and balances in this system to assure that these clinics met the minimum standards that we expect of facilities of this nature. There are a couple of places where we can do a little bit to accomplish a lot, and one of them is with expectant mothers and in childbirth. We are very fortunate to have spent a great deal of time over the past 20 years in this state to enhance health care for newborns and for expectant mothers, but a lot more needs to be done. Birthing centers, midwife centers can provide a warm and nurturing environment where expectant mothers can get support and education from other expectant mothers and experts, the midwives who are there. It can provide such an important advancement for many people who seek that approach toward childbirth. But there's also something else that maybe isn't as warm and fuzzy as that. It's a heck of a lot less expensive to do it in a midwife center, to have a midwife center, than it is to have the traditional means of approach to childbirth. I think the bill memo specifies that $30 million might have been saved already in New York State. Just think how much more might be saved if we encourage the development of these centers. I am very fortunate to live in an area where we pay a lot of attention to these issues. At the Northern Dutchess Hospital, an amazing, beautiful suite has been built for families to go and bring a new person into their life. But also, if you're riding back down to the city or Long Island and you're going down the New York State Thruway, it's a short jump off of exit 19 on Washington Avenue to see the new birthing center, in the new midwife center in Kingston. And even if it's not open, peek in the window and get an idea of how much nicer that is than some of the places you've had to visit when your spouses or children or relatives have been in the hospital to give birth. I applaud the sponsor of this legislation, and I urge unanimous support for it.
Mr. Rea.
Thank you, Mr. Speaker. Richard, would you yield for just a quick couple questions?
Mr. Gottfried, will you yield?
Certainly.
Mr. Gottfried yields.
Thank you. Question. Are there different levels of midwives with respects to education and certifications?
I don't think there is any differentiation in New York law. In New York law, you're either, as with physicians, you're either a midwife licensed by the state education department or you're not. I assume there are midwives with more advanced education. I don't think that gives them any different legal status.
So, I mean, it's my understanding you have lay midwives and then you have certified nurse midwives.
Well, no. People who call themselves lay midwives are scofflaws under New York law. If they're delivering babies, the state education department better not find out about it.
Oh, but okay, so you're telling me that legally they can't perform a birth?
Correct. No more than you and I could be in business doing births or practicing medicine.
All right, but the legislation doesn't specifically detail that you have to be a certified nurse midwife?
Well, there is no such thing in New York other than a legal midwife.
Okay.
Yeah.
And does the legislation include a requirement for the safe and timely transfer of a patient to a hospital or an agreement with a hospital should, heaven forbids, something go wrong?
Well, that isn't within the four corners of the bill. It is very clearly spelled out in the education law. So we don't need to spell that out every time we have a bill that uses the word midwife. It's already, it's in there, like the whatever brand of sauce. I could read you that language if you like, but it is all.
It's in there.
It all applies to everything that this bill talks about.
All right. Thank you, Richard. I appreciate it.
Read the last section.
This act shall take effect immediately.
Clerk will record the vote.
Are there any votes? Announce the results.
Ayes 83, noes 27.
The bill is passed.
Assembly 180A, calendar number 13, Mr. Dinowitz, an act to amend the Public Service Law.
This bill would create the State Office of Utility Consumer Advocate to represent residential utility consumers' interests in residential utility matters at the state and federal level.
Ms. Corwin?
Oh, thank you. Thank you. Yes, would the sponsor yield for questions?
Yes. I was waiting for you to ask me that question.
Thank you.
Thank you, Jeff. Yes, I see you want to create a new position called Utility Consumer Advocate. My question for you is, what's wrong with our Consumer Protection Division of the Department of State, which already has a utility intervention unit who interacts at the federal and the state levels?
Well, I mean, they're okay, but they won't be able to, they won't be able to do what the Utility Consumer Advocate's Office does. Such an office will be able to do much more than what these guys currently do, but in addition, this office will be independent. The advocate will be appointed and confirmed by the Senate for a 6-year term, and then will be independent, not subject to, pressure, removal, things like that.
Okay, so be appointed by whom? The governor?
The governor.
Okay, so this independent person is an appointee of the governor. Okay.
As are other independent people, such as judges, members of the MTA board, people who will be confirmed.
I understand. But you're saying that the individual or the people from the Public Service Commission who are currently filling this function are not independent?
The people who serve on the Public Service Commission have a different role to play. The Public Service Commission's job isn't necessarily to solely represent consumers. They deal with, all parts of the spectrum when it comes to rates, including the utilities themselves, whereas this office, their job would be specifically to advocate on behalf of residential utility consumers.
Okay, I guess I'm confused here because my understanding is within the Public Service Commission is a unit specifically called Utility Intervention, and their job is to, accept and investigate complaints of any kind, to mediate complaints, and to refer complaints to appropriate state and local agencies. But you're saying that that's not what the Utility Consumer Advocate would be doing?
Right. I mean, the office you mentioned, I mean, they have to balance the interests of various parties. They are not necessarily independent, whereas this office, their role is to simply represent the consumers of, and we all represent about 125,000 or so consumers.
Well, I think that's the whole reason we go through the Public Service Commission is because we're in terms of rate increases, quality and pricing of services. That's part of what they do, and that's on behalf of consumers. So I don't understand where
they're not working on behalf of the consumers. The consumers are just one group that they may take into account, but they also deal with the interests of other parties involved, not simply the consumers. We need somebody, I believe, whose role it is to represent the consumers, us, our constituents, and over 40 states have this office, at least 40 states. New York is one of 10 or even fewer states that do not have such an office. We are the largest state, and the states that have a Utility Consumer Advocate's Office, their ratepayers have seen dramatic savings as a result of the existence of that office.
Sure, you're referring to California, I'm assuming?
Among others, there are 40 states. But yes, California, Connecticut is an example. The amount of money spent to run these offices in the states that have them is a tiny fraction of the amount of money that consumers have benefited as a result of the office.
So does your legislation do anything to eliminate the utility intervention unit of the Public Service Commission?
No.
That- Okay, so we still have them operating, doing what they're doing. They believe they're operating on the best interests of the consumers, but you're saying we're going to have a utility advocate as well, so they're both performing the same functions. I agree that you're saying that you don't believe the first one is actually accomplishing that. My point here, though, is we have two different, we would have two different agencies or two different authorities charged with the same function, and I see here in California, that additional cost is over $25 million for the utility advocate. So to me, if we're going to have it, wouldn't it make more sense to just have one so that we're not paying two different agencies to do the same thing?
It could be that once this office is created and funded, that the other office will, sort of fall by the wayside. But when you mentioned the amount of money spent by California, I assume you know that the amount of money saved by consumers in California amounts to billions, a very high multiple of the 25 million that you're talking about. And so spending a relatively small amount of money has accrued significantly to the benefits of the people in California, and as a result, they are paying lower rates than they might have otherwise paid. And that's real money in people's pockets, and that's essentially like a tax cut for people, and I know that that's something which you might think is a good thing.
Well, you know how I love tax cuts. Thank you, Mr. Dinowitz. On the bill, Mr. Speaker.
On the bill, Mr. Corwin.
Fine to have a utility consumer advocate. Of course, the problem I have here is what I had pointed out, that we already have a function within the Public Service Commission that is charged with those same goals and objectives. If we want to have a utility consumer advocate, fine. Well, then let's make sure we eliminate the function within the Public Service Commission. If we have both, A, we're spending twice as much to run this function as we need to. Second of all, it creates confusion for the consumer. Who are they supposed to be dealing with, the consumer advocate or with this unit within the Public Service Commission? Certainly, if we want to have one over the other, we feel one is more independent than the other. I personally don't think an appointment from the governor necessarily makes that person independent, but at the very least, we should making sure that we're not paying two different agencies to do the same function. Thank you, Mr. Speaker.
Thank you.
No. Okay. Are there any other votes? Or whatever.
Read the last section.
This act shall take effect April 1st.
Clerk will record the vote. Mr. Abernathy to explain his vote.
Thank you, Mr. Speaker. I'd like to commend the sponsor for his advocacy on behalf of this legislation. I think an important distinction has to be made that the sponsor already made and should be reiterated. The Public Service Commission are the decision makers, and people who work for them, while they may be termed advocates, are in fact working for the decision makers and therefore are not totally independent of the decision makers. What is proposed in this legislation is to set up a totally independent body whose sole function will be to represent the consumers, have no connection at all with the decision makers, will not have to worry about what kind of information they bring forward so as to perhaps embarrass the decision makers. They will be free to make all of the arguments that are necessary on behalf of the consumers. That's why this has worked elsewhere around the country. I commend the sponsor again, and I hope all of my colleagues will vote for it.
Mr. Abernathy, in the affirmative.